Okay? You make your statement and you shut your mouth. Okay? You're talking too damn much in the damn court and you're going to get yourself in trouble. You're trying to tell them what to do, and basically you're not there to tell them what to do. You're just there to basically make your statement, and then that's it. Now, you listen to them, okay? Now, if they step out of line, then you can turn around and you just file a compulsory counterclaim into the court. Okay, if they're not going to do what you want them to do, you're on the wrong side of the fence. You need to do a counter action or counterclaim. Get them to be the defendant, and now you're the plaintiff. Because your fictional person is the creditor, they are really the debtor. Yeah, that's what you've got to do. And see, you are protected. You just don't know how you are protected, but I put it out in the word definitions there on the site. And I told this the other day, I think. You have a benefit of cessions, C-E-S-S-I-O-N. That means you have given all your assets over to your fictional creditor. Therefore, they cannot arrest and imprison you.
That definition is on the new document you just loaded. Download.
So in other words, yeah, it was just a poker bluff from the judge today on holding you, contempt or whatever, overnight, in jail there, and I'll study. I'm gonna figure this thing out. I got my own thinking. I hear different views.
Yeah, and that's going to be your damn problem. You're trying to put your shit into the thing, and you're going to screw up what somebody else out here is trying to tell you is the right way to do things. You've got too much damn ego and pride. It's not my ego and pride. I've been studying all this stuff to basically put the pieces together. I've had all the pieces sitting here. If people would have listened to what I've said, they might have helped me in the damn process some. We can't liquidate our accounts at the local level. Title 28 U.S.C. 1346 states that at the local level, you can only get roughly $10,000 for domestic support. You can put in all your tax claims and basically hospital bills and stuff like that, but you can't get domestic support at this level. You've got to go to a higher court, and that is the federal or the bankruptcy court in D.C. at 333 Constitution Avenue that we went to before under Title 28 U.S.C. 1491, which is the counter side of H.R. 1491 that took all of our assets away from us to begin with. The mirror image. I get ahead of myself sometimes, but basically I've got all the damn right information here. If people would just listen to me and help me keep on target with this stuff. We do a declaration of device E or of assignee of our patent into that bankruptcy court. in D.C. for the liquidation. That state court, if you got a traffic ticket or whatever, they're hauling you into court on it or whatever. It's a charge. You have to figure out how to discharge it. And the only way you can discharge it, if they're not going to set it off in that damn court, you turn around and file a B-10 into the bankruptcy court against that debtor corporation. But you have to use the proper terms that we're using now in the last two B-10 forms that I put up there. I showed you how to pay a local bill with the local bankruptcy court. That one will be settled. The other ones for the liquidation of the account, I don't think they're going to do a thing with it. I'm going to send a fax off to the U.S. trustee, but he's just like going into the bank. The cashier can't authorize a check for over $1,000 or so. She's got to go up to the next level or even higher. Now, you take a check in for $1 million, and basically that cashier ain't going to be able to do it. Think about this stuff, people.
Yeah.
Think logically, not with your whims and everything else that basically people get into.
Right, that's what you've taught us. That's why you can hear what he's saying and I can hear what he's saying.
Yeah, misdirections that basically you're doing to yourself. There's other people out here right now. Last week, somebody was mentioning Christian Walters with the trust. There is no trust here. It's all under patent law. We are the patent holder or the bearer bond holder. Think about these certificates of live birth. They're a bearer bond. We're the holder of the bearer bond. That's essentially what they are. We're the patent holder, and they're patented. It's a patent claim. Our fictional person is the patentee. The United States of America government, the Emperor of America, the Constitution, was the patentor, or the issuer of the patent. That's simple. When I was in the service, I could not get discharged off of the ship that I was on. I had to go to the discharge station on land. Some other people, basically, they had to go to a special discharge base if they were in the Army for the discharge. We have to go to the port of discharge, the bankruptcy court in Washington, D.C., where our patent originated, to liquidate the account. if you're in a court case, you can do a compulsory counterclaim. You just don't do a counterclaim. You do a compulsory counterclaim. That forces the new counter-defendant to come forward. He has to go on the witness stand or whatever. Read the definitions, what I put up there. I don't put these damn words out here for naught. I do it because I know damn well you guys ain't going to pull up the damn dictionaries and go look up the damn words. Or you may look them up and then basically you forget them. You've got to copy them down. You've got to study them. You've got to read them.
Read them and write them. Yeah.
They're obligated out here under a duty of support. They're holding our asset, our creditor, on board their vessel. He's just like a seaman or a military person in the service. Merchant seaman. He does a week's worth of work, he gets paid. You've got to put his claim in for his paycheck, though. He can't do it. And see, half of these damn things, these agreements and everything, are unwritten. You have to fill in the blanks in the damn process. Injury is an invasion of a legal right. Unless you've harmed somebody and you're out driving, you have the legal right to drive. You're not operating in commerce when you're driving. And if they stop you, they are doing an illegal evasion of your legal right.
You said invasion, right?
Time is money. Your time is value. If they deprive you of your time, they are depriving you and damaging you and injuring you. Go into the doctor's office and he sets you up an appointment for 10 o'clock and he doesn't see you until 11 o'clock, he just deprived you of an hour's worth of your time. But people will stand in line, people will sit in the damn doctor's office and voluntarily give up their damn time. And yet they turn around and complain about some other guy doing the same thing to them, and they get all bent out of shape. Why is it okay on one hand and not okay on the other hand? Because people out here listen to the damn patriot bullshit half the damn time, or some of these other damn nitwits that are out here running around that are copycats in half the shit that they do, and they don't understand half of what's really going on. They don't know who really is in control of everything. They're still trying to do shit at the damn county level when it's not at that level that we need to go to. You need to go to the bank manager or to the manager that is over that area. The county attorneys are nothing but physical agents or county vessel pursers working under the state attorney general's office. The state attorney general is the chief fiscal agent and vessel purser for the all capital state of whatever treasury. He has to issue the warrant over to the treasurer to have a payment made to you or to whoever you want them to make it. But you're probably going to have to do a bankruptcy form against them, a B-10 form, to force their hand. They're the ones that are in bankruptcy, not us. Even though our fictional person is a seaman on their bankrupt vessel, that does not make him a bankrupt. He's the creditor. They're the debtor. The government is always a debtor to the people, period. They owe us. We don't owe them shit. Benefit of bargain rule. The rule of damages that a person who purchased in the reliance upon fraudulent representations of the seller is entitled in an action against the seller for the fraud to recover damages, the difference between the real and the represented value of the property. That benefit of bargain rule deals with your damn Social Security, with your driver's license, with that certificate of title to the vehicle. You just have to put the right wording into that rule. Because they did a fraudulent representation to you. And half the time, the local nitwits that are trying to push the thing, you don't argue with them. Because they only know what they were told to do. You have to either go to the fiscal agent, the county prosecutor, or the court, and they're not a court per se. They are nothing but an administrative, on the document that I'm working up, they are a corporate administrative court bankrupt debt obligation. Obligator or obligor.
I wrote down corporate administrative bankrupt obligator. That's what
a corporate administrative court. Okay?
Yeah.
Look at the address for these courts. Even at the federal bankruptcy courthouse or at the federal courthouse, the United States courthouse, what is the address that basically they go to? It doesn't say office of clerk of the court. It doesn't say office of chief judge. It doesn't say office of bankruptcy court, clerk of the court. At least in my situation here, it's all suite 103, 300, whatever. Suite. Well, a suite is not an office. Right there is telling you something. They are only placeholders. They're not office holders in the constitutional government. They operate with a date that is not correct in the real law of the land dates. They operate in the scenario of month, day, year. That is a pollution. That is a fraud. Fraudulent date. The correct date is day, month, year. That was the proper way to write up when you were going to do a notary, get a notary signature. The way the Constitution was signed was day, month, year. Any real official legal or lawful document is day, month, year. The reason they have to have a last name on our fictional person, that on all these official documents they have, is because they have to have a permanent name. And when you have a last name, you have just made that permanent. That is now fixed. But you as the living can flex your name around any way you want to. You have to not walk in the footsteps of your creditor, of your, in the real world, debtor to you, your prodigal son. He has his footsteps, you have to have yours. And your footstep is your birthing date, B-E-R-T-H, date. His footprints are his date of birth, D-O-B. And the two dates are written different. One is written in legalese, the other one is written lawfully. Yours is supposed to be written lawfully. You're supposed to be operating in the real law system, and you can't even figure that real law system out. That's the problem with most people. You've been polluted so damn much, deceived by half these people. Rob Ryder, Christian Walters, some of these other guys, Rod Class, you name it, all these guys that are basically just going off, and then they won't sit down and listen to anybody. They won't try and contact somebody that might have some good information and sit down and try and work with the guy. I've had an open invitation to these guys to call me up. None of them have said anything about Title 28 U.S.C. 1346 or 28 U.S.C. 1491. Well, 1491 is the mirror image of H.R. 1491 that took our assets away. So if we want our assets back, then we have to go in under Title 28 U.S.C. 1491 to liquidate our accounts and get our patented assets back. It makes that much sense. At least it makes sense to me. I asked you people to put the questions out here. You're not going to get any better knowledge sitting there keeping your damn mouth shut. You've got to ask the questions. I'm not going to charge you with contempt of court if you ask the questions from me. But you start spouting off in a damn court scenario there that you don't know what the hell you're doing, and basically that judge may charge you with contempt, but you don't know how to get out of it. They can try and charge you with contempt all they want in their fraudulent court system, and all you have to say, I purge myself of that contempt.
Yeah.
But also, if you understand what I told you about benefit of sessions, they can't imprison you either, because that is a fraudulent charge. Everything is about money out here. And if you don't have anything, then basically the only one that can go to jail is your creditor. And he's already in jail with them. And you don't go in there and try and tell them how to do their stuff. You try and basically make your statement and then shut your mouth. Then say, okay, I need to have a little extra time. Then you come back and you do your compulsory counter claim and submit it back into the court. Now, your counter claim has to be answered before they can proceed back to the other one. You have just made that county prosecutor, that state of whatever, all capital, or the United States, all capital, corporate bankrupt vessel, the real debtor, and then the county attorney or bar attorney or the U.S. bar attorneys, the co-defendants in the process, and whoever the attorney is or the prosecutor is in that case, they are a physical agent and court purser. They're the paymaster. You have to get them to pay. And the only way you're going to get them to pay is to make them the defendant. They will pay and settle the charges. The charges are against your creditor, not against you. And they will basically take it from the funds, the duty of support that they owe to that creditor. But you can also put additional charges of injury, damages into that compulsory counterclaim filing. You don't take these word definitions, like take counterclaim there, and it has plaintiff. Well, you got to look at it. Is that the original plaintiff, or now is that the counter plaintiff in that definition? You need to look at them. You need to mark them up so that you understand them. That's why I highlight a bunch of these items when I put the word definitions out. I'm trying to help you people. A benefit in their corporate world is an injury in our world. And that is in the definition of benefit. Hope is a command. Just as big as an order. It is an order. It's a command. It is my hope that you will honor my will. It is my will. You're the Father. Say the Our Father over until you understand who is who in that prayer. That is a court prayer. Benefit of sessions, immunity from imprisonment for debt of a debtor. You're classified as a debtor in their corporate world. But you're really not the debtor. But you have assigned all of your assets over to your creditor, to your fictional person. So you have immunity from imprisonment. And that's a civil law. Now, what are they going to do? Violate their own civil law? Then you've got 18 U.S.C. Section 242. You've also got 42 U.S.C. Section 1983. That gives you the right to turn around and file charges against them for injury, for violating the real laws. You even got the 14th Amendment. There are things in that 14th Amendment that give you protections. But everybody's been looking at that as totally bad. There has to be a remedy in everything that they put out there. You just have to find the remedy. Now, like I said, you can turn around and file all your taxes, your hospital bills, your utility bills, anything you've got into that local bankruptcy court, federal district court. Using the B-10 form. I tried to put it in there, but basically now they have to turn around and start telling us when they made the deposit. See, the form doesn't say anything about that.
Could you repeat that, Patrick? The sound screwed up for about 30 seconds.
Yeah, all you have to do is read the damn document. I put it in right on the final signature there, that basically they have to turn around and notify us when they have made a payment of a bill.
Okay.
Just like the local banks anymore. They don't want to give you your printout of your checks when they've cleared. They're trying to make it as hard as possible on you. They don't want proof that they've done something out there so that other people can show it to other people that, hey, this really works. There is no format out here. That's why it had to be trial and error to find out what the proper combination was. There's a bunch of misleading information out here that I've been trying to work on the trial and error process of going down one road and trying to stick with it and not go running over to all these other guru holes and hopping down them and going different directions. We've done all that in the past. When you go into the bankruptcy court in D.C. to do your liquidation, you will also do a declaration of your assignee's update of patent into that bankruptcy court. That's where your declaration of patent needs to go. Because where's the patent office? It's headquartered in Washington, D.C. How many people you got on the call now, Tom? Tom.
He might be muted out.
Okay, anybody's got any questions, ask them now, or forever hold your damn peace. Star 6 if you want to unmute and ask your question.
Well, I was just going to say that you mentioned that there's an obligation for them to support us, and they're obligated as a duty of support. And you mentioned that that was the HR 1491. And the remedy was Title 28 U.S. Code 1491. You also mentioned, I think it was 1326, and then also
1326 is at the local level, and basically in that it says $10,000. I think is the max that they could do, but they can do other items that are higher, like setting off utility bill, hospital bill for $25,000 or whatever.
Mm-hmm.
Okay.
Right.
Taxes, $150,000 taxes or whatever.
Mm-hmm. Yeah, we should get familiar with that, so I'll read those.
Yeah, and see, basically then they try and put a damper on things and try and make you the debtor in the bankruptcy court. No, you're always going to be the creditor.
Mhm.
You're not the bankrupt.
Right.
The corporations are the bankrupts.
Mhm.
Even that local bank is a bankrupt. Where'd they get the money to get the house? They turn around and use your creditors as the guarantor in the process. And see, we've been signing these contracts, these mortgage contracts, with them.
Right, and
It's
promissory
in
notes.
their world.
Yeah.
Okay, we sign on the right-hand side. Well, that's on the debtor side. On the right-hand side. Not the creditor in their world. The mirror image. They put our fictional person's name on the left-hand side. He is the creditor. He's got the money. You don't. He's got the credits that are owed. Now, the bank owes him, the creditor, on that mortgage.
Yeah.
He's the obligee. The bank is the obligor. They wrote the bonds to basically make the payment for the house, so now they owe the interest back from the bonds to the creditor to make the settlement for the house.
Yeah.
But see, now you have to do a counterclaim in the court for that house, for that mortgage, so that you can force the bank to make the payment now. Or you take them into bankruptcy court. You've got to get on the right side of the looking glass.
Mhm.
We thought we were, but basically, we're not. We weren't getting there. That's why we never got anything, because we were still on the wrong side of the looking glass. We were throwing shit at the glass, but basically it wasn't sticking.
Right.
It wasn't going through.
You know, when we study it further enough, then we will not fail.
Only if you keep on target, okay, on the right path. I get so sick of these people that are wanting to go out here and do a trust this and a trust that, comprehensive trust or whatever type scenario. In a trust, you have to have a trustee now in that trust. You can't be both the trustee and the beneficiary in a trust.
Right.
The only way you can have both sides in the process is to be a private enterprise out here, or a private estate. Then you're the owner. Then you can be every damn thing you want to be. But it's all still within you. You take the responsibility in that scenario. But when you start doing a trust, you are not taking on your responsibilities the way you're supposed to. And half these people that are operating with trust, that people see, oh yeah, that guy's can go into court and basically get off of things. Well, basically there's another reason why they're getting off, and I've said that before. They've got a ring on their finger, and you don't have a ring on your finger. They're in the Brotherhood. But they're still in the corporate system. You just don't see it that way.
Yeah, you said they're not official office holders. They're just placeholders. And
they're just placeholders.
Yeah, and they're just corporate.
They're just corporate entities. They're holding a place down.
Right.
They're not an office. And basically you can look that up in officer definition. I put that up there before too. And I've said this numerous times over, that basically a woman cannot be a judge over a man. So if you've got a woman judge, she's got to be just nothing but a corporate administrator, placeholder. Now you've got to figure out how to make the administration of that process work to pay the bill. It's just nothing more than a glorified bank. She can be a vice president or whatever at the bank. And that's all that vice president is an administrator within the bank system. And they're all bankrupt corporations. Anybody else got any questions?
Pretty quiet out there.
Tom, you there?
Strangely quiet.
Well, I'm here. I'm just trying to keep my mouth shut because I recognize how ignorant I am.
Well, you'll stay a lot more ignorant if you don't ask some questions, okay?
Well, okay. Well, for example, today, why not take it as an example? That my court situation where an old matter, the warrant, I went there and I figured I would stand in as authorized representative just to try to settle the matter. And the judge wanted to ask, he kept asking, are you so-and-so, the name? And I said, how can I tell you, how can I show the court that I am or am not? What would constitute proof? How would the court know? And he seemed befuddled by that. And in a minute...
The only way you can prove to that court you are not basically the one that they're charging as the defendant is that you have to make clarification. My birth date is this. The date of the one that you are charging, just like on your driver's license, it has DOB. At least in the state of Iowa, it has DOB in red. And then it has the birth date in the wrong format. My lawful birth date is 90 days after. that initial, what they call BIRTH date, is the date that you separated from your mother from the birth canal, and you also abandoned your birth sac. But you've been walking around in the same footsteps as that birth sac, the mirror image. That's the date your birth sac was born, laid out as a dead entity. You have to claim your lawful birth date, your birthing date, BERTH date, which is 90 days later.
In the correct format.
Yeah. In the day, month, year format. That is when you are 1 year old from the date of your conception. That's what you have to separate your footsteps to show that you are not the other person. That they want you to walk in the same footsteps as that other fictional person, then you've got to be him. All you have to do is say, my birthing date is this date. His birthing date, the one that you are charging out here, what is his birth date? What birth date do you have for this person that you're charging? Ask him that question. Well, say that can't be me because my birthing date is this date. And I'm coming in as the attorney in fact for him.
And then I tried doing the whole authorized representative of that person, but he said you got to be a member of the bar and did that whole shenanigans.
That is total bullshit. You are an attorney in fact, and you don't have to have a bar card to be an attorney in fact.
Why
Look at the bankruptcy or the IRS forms for power of attorney.
Well, that makes sense. Now what sounds like the next logical thing to do would be get the record of the court.
No, you'd file a counter, a compulsory counter claim against the state of, if this was a state case, or the United States, and then that prosecuting attorney. Make them the defendant. You come in as an attorney in fact, and also with your creditor as being the plaintiff against them. But you need to sit down and think this thing through. I've done cross-action filings in the past. But you only do a cross-action if the case is totally closed, but you can always reopen one of these cases and do a compulsory counterclaim against them. Because there is no statute of limitation upon fraud. And they are continuously operating in fraud. They tried to tell you that it was mandatory that you have a driver's license. No. You only need to have a driver's license if you're operating in commercial operations. But they didn't tell you that.
Hey Patrick, DOB also stands for Department of Banking or Division of Banking. So one could actually be your birth date and the other could actually be your account.
What's that? Again?
I said DOB also stands for Department of Banking or Division of Banking.
What the fuck are you talking about, boy? Or girl? God damn it. Department of Banking has not a fucking thing to do with DOB when it's got a fucking date behind it. You go to the fucking hospital, DOB. What's your date of birth? What's your date of birth? Date of birth. Date of birth. Where the hell do you get that to be a banking damn statement?
That means an account.
Yeah.
I said it was an account. They operate it as an account, an access to your account. That is the name for your merchant seaman. His account number, 8 digits behind the 9 or the 3 digits there. The 3 digits for the district you're in, and then you've got an 11-digit account number just like on your checks. It's not the routing number. That's normally the Social Security number, a 9-digit number. Or transmitting like an EIN number. Those are just routing numbers in their damn corporate system.
Yeah, Patrick, I got bounced. My computer froze up. I just rebooted.
Okay. Take the one down for the liquidation because people will probably try and do that one into the local bankruptcy court, and that's not the place it needs to go. That needs to go to Washington, D.C. bankruptcy court there. And then it needs to, the notification needs to be sent to the Attorney General's Office of the Attorney General. He will be the master trustee, fiscal agent, and main mother vessel purser to write out the warrant to the Treasury Department to have our funds transferred over to us under our patent.
Okay, I'll pull it down, but we can still study it for all the other material in there to learn the process. So
he would also be the one to issue the warrant to go and seize the property from the Church of Rome or from the Social Security Administration or from the Department of Defense under the DD 214. But he's the one that's got to issue the warrant at the main level. See, we had all the bits and pieces here. We were just using the wrong terms because we got totally messed up on thinking that we, the living, were the real creditor, and we're not in their world. we will have our credits in our hands when we come out, and then we won't. Essentially, we'll just be the owner, the enterprise estate holder. Any other questions?
When we do get,
How many
when we
people
do
you
get,
got on the call, Tom?
well, there 7 people. Well, actually 8. Actually 8.
Yeah, they must all be over there listening to Rob Ryder or Christian Walters now. So,
No, not me.
I give up.
I'm here.
Yeah, Chris. That's he's on with me on Skype. Chris.
Yeah, they want to go do trust stuff and basically keep playing around at the damn county level and basically not go down and do any of this damn stuff. Not realizing that basically the damn judges were telling us stuff and basically people don't want to open their eyes and see what we might have been missing in the process. We've been looking for the damn physical agents this whole damn time, and it was right there in the damn Justice Department. Attorneys. The county attorneys, the prosecutors, the U.S. attorneys, basically they're all physical agents in the Justice Department that have to interface then with the Treasury Department to make the payments. They're the paymasters, the yeomen, the vessel pursers, however you want to look at it. They're the ones that we have to force to make the payment to our creditor. From the bankrupt. Okay. Call tonight, Tom. Tom.
Hey, I got one other question for you, Patrick.
Okay.
Yeah. So I looked for the territorial court, and apparently the clerk at the federal bankruptcy court, had no idea what that is. So
there is no territorial court in the bankruptcy system. The territorial court is over at the federal chief judge's office. There is no Article 3 court in the bankruptcy system. The Article 3 court is over in the federal court building or in the courthouse, but it's through the clerk of the court over there. You've got 2 different clerks of the court, one for the bankruptcy court and then one for the other court system. And they're going to give you a song and a dance in a lot of cases about this. That's why you've got to address it to the office of the chief judge. not to the suite or whatever of the suite judge. But your compulsory counterclaim, that is what you need to do if you're in a federal court, you need to do that to do the filing into the system, to get them to be the defendant. They're the bankrupt, not you or your creditor. And the court case is not against you anyway. It's against your creditor. They're trying to get funds from him. It's a shell game. Tom.
Yeah, I froze again. I'm back.
Okay, go ahead and close her down. I'm done.
Okay, thank you.
Yep.
That's the last. Thank you.
I'll try and get a copy of this compulsory counter court document, a basic one up there for people to look at.
Great, thank you.
Okay, we'll talk to you later. Good night.
See you. Bye.
Okay. See ya.